Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Bhanu Virendra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but you're welcome to this show, and she has been putting a lot of wealth of free information on the Reddy ESQ website for the benefit of US employers and the immigrant community. Hello, Ms. Reddy, welcome to the show.
Hi, Tarani. How are you? Thanks for having me on the show.
Thank you so much. I'm very well. Thank you. I hope you're doing well as well. And today we're going to discuss about the I485 visa bulletin FAQs, and we will continue the knowledge session along with the news and updates on latest immigration, followed by the Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask tips. Well, Ms. Reddy, so are there any specific immigrant updates that you want to give us, tell us our viewers?
So the update is that we're still waiting for, the budget reconciliation bill to be passed. It's passed by the House, but we're still waiting for it to be passed by the Senate, and we need to see then what immigration provisions they manage to keep in there, and if there's some benefit to, of course, the Dreamers, and also benefit for the immigrant visa numbers if they agree with, the scheme of paying $5,000 and being able to file your 485 even if your visa number is not available, as long as you waited for 2 years already. And also we have to wait and see if they agree to use the unused visa numbers from previous years. So we're waiting for that, and I think that news will also impact the November visa bulletin. October visa bulletin we spoke about last show, but I thought we should do a part 2 because there's so much more to talk about and we didn't have a chance to cover everything.
Right. So we have a caller on hold, Mr. Shekhar from New Jersey. Thank you for calling, Shekhar. You may ask Ms. Reddy your question directly.
Hi, this is Shekhar here. Good evening.
Hi, Shekhar.
Are you able to hear me?
Yes, we can. Go ahead.
Okay. Mine is EB2 to EB3 scenario. I downgraded my petition, and I-140 is approved. 485 is filed. And then my biometrics is, it's scheduled. I have a question on biometrics. For my wife and myself, right, in 797C form, the code is written as 3, and for my daughter it is 2. Could you please tell me the difference here?
As far as I know, the code is C09. I don't remember exactly, but the code should be C09 on the 765. That's the code used for 485 employment-based EADs. The 765 is used for many different purposes, and this is only one purpose, and that's how they identify, on what basis you're getting the EAD. But I would think that since it's being filed with the adjustment of status application, obviously they know it's based on the I-140, and it's based on, employment-based petition. So,
okay.
Worst case scenario, they'll send an RFE asking to correct and put the proper code.
Sure. My daughter is 13 years. I mean, she's minor. That's why it may be a different code, I think.
No, it's on the 765, it's the same code. It's based on, since all of them are getting it on the same basis, it's all supposed to be employment based. Even though they're getting it as derivatives of you, it's all employment based, so it should be the same for all three of you.
I sure got it. I have one more quick question. That is, my 485 is pending, right, for the last 2 months now. If I want to change the employer, right, what is the procedure? Do I need to receive my EAD card, then only I can change my employer?
No, since your I-140 is approved and your 485 has been pending for more than 6 months, you should be able to change your employer using that 485J, as long as the job is same or similar.
Right.
All right, ma'am. Okay. Got it. Yeah. Thank you.
Right.
You're welcome.
Ms. Reddy, could you please explain to us the eligibility and process of EB3 to EB2 porting?
So basically, usually the porting is from EB2 to EB3 right now, because in October and of last year and the months following that, EB3 has been moving faster than EB2, and the dates for EB3 are better because there's more forward movement. So a lot of people have been downgrading their I-140 petition by filing another petition from EB2 to EB3. So the act of downgrading simply means that you're filing a new I-140. So you're not filing an amendment. If you file an amendment, then you're losing your previously approved EB2 I-140. So you're not doing that. You're not checking the amendment box. Instead, you're just filing a new petition, a new I-140. And you're allowed to do that as long as you qualify. And you do qualify because you meet the minimum requirements of an EB3. If you filed a labor under EB2, you obviously meet the minimum requirements for EB3, because EB2 requirements are advanced degree, and so obviously you have at least an advanced degree or corresponding experience. So you will definitely meet the EB3 criteria, so you can file. Of course, you would file with a copy of the labor cert, because you would not have the original labor cert. The original labor cert would have been filed with your previous I-140. So in that instance, then you will not be able to premium process. So you'd have to go with regular processing. And then consequently, you might be able to convert to premium processing, provided that particular service center has your original labor approval handy. Otherwise, they could reject the premium processing request, in which case you can refile it, and hopefully by then when you refile it, they will have the original in hand.
Right.
So the other, can I continue, or do you have a caller?
No, please go on.
Okay. So the only aspect of the the conversion from EB2 to EB3, which is tricky, is not really the qualification of the beneficiary, because obviously you're qualified. That's why it was approved previously. Unless it was approved by mistake, then of course that could be an issue also. But generally, the most important issue is the ability to pay, because the employer now has to show that they have the ability to pay the prevailing wage, and that they have continued to have that ability from the date of your last, from the date of the approval to now, to present. So, and as we know, a business doesn't always have the same profit. So the profits of a business can fluctuate often. And so, if there change circumstances in the business and they're not doing as well as they were, or if the employer is not being paid the prevailing wage, if they're already being paid the prevailing wage or more, then the ability to pay is not an issue. The USCIS doesn't actually look at the tax returns, and so it doesn't matter whether the business is doing well or not, or is able to show profits. the main criteria is that the employer has to have the ability to pay. So that could be one issue in downgrading. Another issue, as I said, could be that if they made a mistake, they might come back to it and ask for all the documentation again. And there is a chance of denial. And if that happens and you're filing the I-140 and 485 concurrently, then your 485 will also get denied. So that there is a risk involved in filing the downgrade and the 485 together. But I understand that there's no other way out, because a lot of people, most people would want to take advantage of the priority dates being available, and they don't have the luxury of waiting for the I-140 to get approved first, the downgrading to get approved first, and then filing a 485. So these are some of the issues that I wanted to highlight when you're downgrading.
Right. So, Ms. Reddy, my next question is, what is an advance parole and who needs it?
So an advance parole allows you to travel back into the US without a visa. So that's a huge benefit, right? Because especially now with the pandemic, the consulates being closed and expedite requests being refused, people are being stuck for a lengthy duration of time outside the US. And also the process of obtaining a visa itself is so cumbersome and arbitrary, because you can't really appeal if your visa gets denied. You just have to go with that decision, and you might be stuck outside the country and not be able to come back. So that's why it's always a huge benefit to be able to be free of that, the necessity of having a visa petition, a visa in your passport. So the advance parole is exactly that. It's a visa which you get, which allows you to travel without having to actually get a visa stamped in your passport or going out of the country. And that is usually given for people who have, it's an incidental benefit that's given to people who have filed 485s. So it will continue to be in approved status as long as the 485 is approved. If the 485 gets approved, denied, then of course you can't use your advance parole. And once the 485 gets approved, you don't need to use your advance parole, because then you'll have a green card.
Right. So, Ms. Reddy, after...
So one thing to run you.
Right.
One quick additional point on this is...
Please go on.
The advance parole. A lot of people think they can file the advance parole and then leave the country after the biometrics are done. But that is unfortunately not, USCIS is not allowing that nowadays. So if you leave the country after you file for advance parole, before it gets approved, while it's pending, then what they're doing is they're denying the advance parole. Then you'll have to come back. Hopefully you have a valid visa. You can come back on that and then reapply for the advance parole. So that's something to keep in mind, that if you want that advance parole to get approved, you would have to wait in the US until it actually gets approved.
I'm sure our immigrants and viewers will keep this in mind. So moving on to our next question. Ms. Reddy, let's say somebody has gotten their green card, right? So is it legal for that person to be working for two companies at the same time?
Well, once you get your green card, you're free. You can work for n number of companies at the same time, as many as you want to. There's no longer any restrictions once you have a green card. The only restriction that you have is that you have to be living in the US. You cannot stay out of the country for more than a year at a time. Then you stand a chance of losing your green card, unless you're able to prove that you did not intend to give up your residence in the US. But otherwise, employment-wise, you can work for whoever you want. You're completely free, like a citizen. The only restriction is, or kind of restriction is that once your green card gets approved, I do suggest it's prudent to work for the employer that petitioned your green card, at least for 6 months. And then after that, if, it's not bonded labor, so you don't need to be stuck to one employer. If you get a better opportunity, you can always move. This I'm saying is because, when you file for citizenship, then they might see whether you actually worked, for that employer after you got the green card. So, and if you didn't, they might then question the validity of your green card itself, and they might deny your citizenship. And in some circumstances, they might even go back and if they find more problems in your green card, and if they feel that it was approved erroneously, then they can always go back and cancel your green card as well. So you don't want that to happen.
Right. Right. So, Ms. Reddy, could you also tell us about the AC21 job portability?
Yeah. So job portability, like the viewer had a question about, I think, and we kind of touched a little bit on the AC21 job portability. So if the your 485 is pending for at least 6 months, and if your I-140 is approved, if both the conditions are met, then you have the ability to switch your employer. So they made it portable so that you're not stuck with the same employer for years and years and years, because the government is aware of the fact that sometimes visa numbers are not available for many years, and especially Indian nationals are stuck with a 485 pending for 10 years or more. So they want to give some flexibility to the person who has filed a 485 and allow them to, seek out better opportunities and change jobs. Now, the only restriction on changing jobs is you have to make sure that the job is same or similar. So it doesn't have to be same, it can be similar. And similar is a pretty wide, they'll use the term very loosely. So similar could be, for example, you're working as, your perm was filed as a programmer analyst, and now you're working as a software engineer, or even you're working in hardware. It's still similar because, it's still in the IT field. But for example, if you're working as, your perm was filed as a programmer analyst, but now you're working as a financial analyst, that may not meet the cut of the AC21 regulations. So something to keep in mind. So as long as, and the salary also, I would suggest that the new job is paying you more or equal to the salary that was mentioned on the perm. It's prudent to do that. Otherwise, there's no restriction. There's no requirement that you have to inform USCIS as soon as you change jobs. There's no such requirement. So a lot of people take their own time to update the USCIS that, their jobs have been transferred to another employer. Some people even do it 6 months later, more than 6 months later. Some people don't do it at all until they actually get an RFE from the USCIS. So there's no, it's prudent to do it, but there is no rule which says that within a certain number of days of changing employment, you need to notify USCIS with the 485J.
Right. So, Ms. Reddy, in relation to this, let's say can someone leave their sponsoring employer after they file the I485?
Yeah, based on this AC21 that we talked about, if the requirements are met, then yes, absolutely, they can leave their sponsoring employer, because now the new employer will be sponsoring them. So at any given point of time, there has to be a sponsoring employer, and they have to be working for that sponsoring employer. But they can keep changing employers, and that new employer that they work with has to actually offer them a permanent offer of employment and fill out the 485J and sign it and send it to USCIS. But yeah, they can transfer, but at any given point of time, you have to have an employer attached to your 485 petition and an offer of current offer of employment.
Right, right. So my next question is, does a person need forms for his or her children born in the US?
If you're born in the US, you're a US citizen, so you don't need to file any forms for them. They're already US citizens. You do need to, in the 485 there is mention of their name, because there's a question about your spouse, your children, and what the status of your children are. So you have to fill that information out, but no further additional information is needed.
Right. So, could you explain to us the effect of H-1B denial on I-485?
There's no effect of H-1B denial on a 485, except for the fact that you will not be on a H-1, you will be on a pending 485. So you don't have to leave the country. You can continue working if you have an EAD approved. When you leave the country, you have to have an advance parole so that you can come back, since you're not on a H-1 anymore. Also, I think the reason people have a H-1 is that because they want to have a backup in case, especially if your I-140 is not yet approved, it's possible that the 485 can get denied upon denial of the I-140. It's also possible that the 485 can get denied for other reasons. If you don't qualify for adjustment of status, and there are many reasons why one wouldn't qualify, such as, criminal record, or you don't qualify based on health reasons. So, or you don't qualify because you did not maintain status previously. So if your 485 gets denied, then you don't have a backup if you don't have the H1. So that's, so then you'll have to leave the country as soon as the 485 gets denied. And then you'll have to come back on a fresh, file a fresh H1 and then come back, get a visa, and then at the consulate, and then, come back using that visa. So that's the effect of a 485 denial. Also, the issue with the 485 denial is if you're in status, actually there's no issue, but if you're out of status, if you're not on a H1 and your 485 gets denied, you could be you could be in removal proceedings. You could be put into removal proceedings because your status was only dependent on you having a 485. Now that it's denied, you have no status. So you'll be forced to leave, at least within 30 days, you should leave. And then, take other measures to come back. So that's another effect of a 485 denial. Also, your family members aging out. If your 485 gets denied, then obviously everybody has to leave, because you cannot be on a 485 and your children and spouse be on a H4, right? So they will also be on a 485. So it's a little drastic when the 485 gets denied. But if you're on a H1, then there's a buffer because, you still are in status and you don't have to leave the country. You can refile for the 485 once your priority date becomes current again.
Right, understood. So when can one file for an I-485 adjustment of status?
Well, you have to wait for your priority date to become current, and you have to have an approved immigrant petition. It could be an I-130, which is a family-based petition, or it could be a I-140, which is employment-based, or it could be a 360 or a religious petition. So there has to be some immigrant petition that is either approved, or you can also file concurrently a 485 with that petition if you qualify to file that immigrant petition. For example, you can file the I-140 and 485 concurrently, or the I-130 and 485 concurrently, provided your visa number is available. So, and of course, you have to qualify. For approval, you have to qualify, but which we spoke about earlier. But for filing, yeah, that's the requirement. And of course, you have to be in the US. You can't be outside the country and file for a 485. Then you have to file an immigrant visa petition if you're outside the country. So that's another eligibility criteria to file. You have to be in the country to file.
Right. So what about a situation where a person is laid off before getting their green card and their I-485 is still pending?
Yeah, so then in that situation, they can use AC-21 like we were discussing.
Right.
And then they can, change jobs. But I understand there might be a gap between, one getting laid off at one place and then joining another place where they're willing to, offer you permanent employment on the terms and conditions of the green card. So, but I don't think the gap is, though, I did say previously that at any given point of time you should have an offer of employment, but I don't think of a gap of a few months is something that USCIS takes seriously or looks into that carefully. I've not seen that. So you should be okay even if there's a gap, but it would be prudent to try and get an offer of employment and send out that 485J, or at least get an offer of employment as soon as you can after being laid off.
Right. So, should a person maintain their non-immigrant status after filing for I485?
Again, as I was discussing in the previous question, there's some benefits of having the buffer of a H1B status and a 485 status, having two so-called two statuses. So if your 485 gets denied, then you don't have to leave the country if you're on a H1. So that's a good thing. You can just refile the 485 once you qualify. Also, with reference to aging out, if you're on a H1, a lot of people like to maintain their H1 even after they get their 485 because if they have because they have children that are aging out, meaning children that are going to turn 21, and if you don't maintain your H1 and they are not on H4, and everybody is on a 485 status, when they age out, they simply have to leave the country and then come back on a fresh status. But if they're on a H4 and they have a 485 pending, if they age out and the 485 gets denied and they don't have to leave the country, they have to change status, of course, but it's easier to change status from H4 to F1 or some other status, but you can't change status from just a 485 pending petition. You have to leave the country. So it's just easier to transition if you have a non-immigrant petition also that's active.
Right. So, so where can one find the visa bulletin and how often does it get updated?
So the visa bulletin is available on the visa on travel.state.gov. Under that, you have to go to the visa bulletin, and it gets updated every month. And we get the visa bulletin announcement about what the numbers are going to be for next month, usually around the 15th of the previous month. So we have about 2 weeks to prepare your application and your document to file, as soon as October, as soon as the next month comes in, which is October. So this advance notice is good.
Right. Okay. So monthly it is. So my
Correct.
next question is, when a person gets his or her green card, does it mean that their family members will automatically get their green cards too? I mean, is this a myth or is this true? And if it's a myth, would you please bust it?
Yeah, with pleasure. So yes, once you file for yourself a 485, your family member doesn't automatically get a green card unless they file for their own green card separately. And they meet all the requirements of a green card separately on their own. So it's possible that even after they file their 485, your 485 might get approved and theirs might get denied because they don't meet the requirements for adjustment of status. So yes, absolutely. Everybody should file their own separate petition in order to get the green card and meet the requirements of a green card independently. So yeah, I hope that answers your question.
Right, it did. So, since we're talking about the I485 again, could you please run us through the documents that are required to be submitted for the I485?
Yeah, so there are quite a few documents that have to be submitted in a 485 case. Most important I wouldn't say one is more important than the other, but you have to submit, for example, proof of your status. You have to show that you have been in status at least from the time that you re-entered, from the time that you last entered into the country. So if you were not in status previously, but you left the country and came back, then that kind of forgives everything. But from the date of last entry, you have to be in status. Now, say that you were not in status for a few months, even after coming back, and even after your last entry, you forgot that, you forgot to extend your I-94. You didn't notice that it was expiring. So by the time you filed it, it was late, and you finally got the approval, but there was a gap in your status. So just to let you know, under 245K, section 245K, 6 months of out of status wait is allowed, but not more than that. So there is some relief there. So you have to submit documentation to show that you've been in status. So that is, copies of your I-94, copies of all your approvals, the I-797s. If you're on an employment-based non-immigrant status, then your pay stubs, maybe letters from your employer, W-2s to show that you're on the payroll of the company and actively working for the company.
Ms. Reddy,
then you have,
I'm really sorry to cut you in between, but we have a caller on hold, Ms. Sakshi from Connecticut. Thank you for calling, Sakshi. You can ask Ms. Reddy your question directly.
Hi, Ms. Reddy. This is Lakshmi from Connecticut. I have a quick question.
Yeah, go ahead.
Hi. I've seen that recently the dates have been retrogressing. I've seen the visa bulletin that in November visa bulletin the dates might retrogress. So what's happening to the people who get EAD AP? Are they going to be in the indefinite waiting line if their priority date retrogress? Or what happens? You submit your fingerprinting and you're here to receive your EAD AP. Will you receive your EAD AP though your dates retrogress?
Yes. Your case will continue to be processed actively. You will get your EAD AP.
Till your date gets current, you'll get your green card. Otherwise, you'll get your AP EAD card. That's it, right?
Yes, that's correct. You'll get your EAD AP. Your documentation-wise, you will be processed in the sense that if there's any document that they need, they will ask for it. They will send an RFE. They'll keep your case documentarily complete so that, once your date becomes current again, unless medicals are needed, they are able to request a visa number to be reserved for you, and they are able to then approve your green card.
Is that, thank you. That's about it. I think so. That's it. Thank you. Thank you so much.
Okay. You're welcome. Bye.
Hope that answered your question, Sakshi. So, Ms. Reddy, you were telling us about the documents that are needed to file the I485. Could you please go on with that?
Yeah, so as I was saying, status documents are needed, and I was talking about 245K. In addition to that, you would also need documentation to prove your identity. So your passport copy to show that you're a, national of so-and-so country, and then so that they know, what priority date applies to you, because every country, as we know, India and China are backlogged. So, that shows your identity basically. But there's one point that I need to say here, that the priority date is based on not on the place where you're a citizen, but it's place of birth.
Right.
So, for example, if I'm born in England but I have an Indian passport, I would still come under the worldwide category because I was born in England, right?
Right.
So that's important. So that document, of course, passport will show that because it will show where you're born. But more importantly, what you would need for that is your birth certificate to show, where you were born. Same way, if, for example, you are the primary applicant and your wife was born in a different country, like in England, but you were born in India, then there's something called cross-chargeability. So you will be still considered to be a person born in UK. Everyone, the entire family, will be considered as per the UK priority dates, which comes under worldwide, so it's current. So that's an important thing to note. And so the document required for that is, a birth certificate. That's why birth certificates are important.
Right.
And they also identify you, and just as, the passport identifies you. So in addition to that, you would also need to show proof of relationship. So if, as a principal, you're filing for your dependents, there has to be proof of how they're related to you. Otherwise, they're not eligible to file the 485 with you. So your spouse would have to have a marriage certificate. Your children would have to have birth certificates, so on and so forth.
Right.
In addition, and just cut me off when you have a caller, Tarani. So,
I would have to do that right now. Right.
Okay, go ahead then.
Yeah, we have a caller on hold, Ms. Geeta from Texas. Thank you for calling, Geeta. You may ask Ms. Reddy your question directly.
Yeah, hi Prashanthi Reddy garu.
Hi.
I have a question. Actually, I applied for H4 and H4 EAD, but still I didn't receive my H4 and H4 EAD. So meanwhile, I got my AOS EAD and also 140 is pending. So can I use my AOS EAD, and once I receive my H4 EAD, can I switch back to H4 EAD?
No, unfortunately, you cannot do that. You cannot switch back. You can use your 485 EAD.
Actually, yeah, my
But,
lawyer told that I can switch back if I maintain the H4 status. So
No, that is wrong.
Can you please?
I'm sorry, I have to disagree. I have to strongly disagree with your lawyer, and you can cross-check with other attorneys as well, or do your own research. But it's very clear in the law that if you move to EAD, then you're moving to a 485 status. So you're moving away from your H4 status to a 485 status. Once you're in your 485 status, you cannot switch back. There is no such thing as filing a change of status back to a H4. So the only way you could do that is if you leave the country, come back on a H4, and then you can use your H4 EAD. But within the country, you cannot file for a change of status from pending 485 to a H4. So maybe that's what he told you, or there was some confusion. I don't know what it is. But yeah, I hope it's clear that you cannot switch statuses by staying in the country. You can only get back onto a H4 status if you leave and come back on a H4. And then, consequently, if you're able to use your H4 EAD, then you can. So that is quite clear in the law. And if you want to switch, I understand your pain because, the H4 EAD is taking a long time. You must be having a job that you will lose if, you don't have the ability to work. So I understand, what you're going through. But unfortunately, this is the law. If you go to 485, then you just have to stick with the 485. You won't be able to get back to H4 unless you leave and come back. And the other issue also for you is your I-140 is not approved. So if you switch to a 485, unless you're confident that, you have a really strong I-140 application, you might then end up falling out of status if your I-140 gets denied, because then your 485 will also get denied and you will not have that H4 to back you up. Then you'll have to leave and then come back on a H4.
Right. I'm sure that answered Geeta's question, Ms. Reddy. So you were telling our viewers about the importance of a birth certificate and the place of birth and also the proof of nationality. Would you want to go on with that?
Yes. So my favorite topic is the birth certificate. So,
Right.
We find all these boring topics interesting because it's our bread and butter. So we have to find it interesting. But I guess it depends on your need. So if it's something that you need, you will find it interesting. But anyway, so for the birth certificate, what is important is that it should be registered at the time of the birth. And if it's not registered at the time of the birth, then you're allowed to submit a late registered birth certificate. But then you'd have to submit, if you're an Indian national, you'll have to submit secondary evidence of your birth, And the acceptable secondary evidence for Indian nationals is birth affidavits and also school leaving certificates. So what you call a TC certificate, a transfer certificate in India,
Right.
that
Yeah.
certificate. And also you could submit a letter from the hospital where you were born, or you could submit a letter from a priest or a church where you were Christian. So those are the acceptable secondary evidence for Indian nationals, and the Department of State has different documentary requirements for different countries based on what the situation is in that country. But in general, for example, and also then we're talking about late registration of a birth certificate. But if you don't have a birth certificate at all, then you have to submit something called a non-availability certificate, which you have to obtain from the municipal office where in the town that you were born, or any other body that is authorized to register deaths and births. And that certificate or that letter has to say that they have looked for your records and there is no record of your birth in their database. So they're saying that it has not been registered in simple language. So you need the non-availability plus the secondary evidence then in that situation where you don't have a birth certificate. If you were born before 1970, then it's presumed that the birth certificate is not available because the laws were such in India that it became compulsory to register the birth only after 1970. So if you're born before that, then I believe it was 1970, but I look it up. But if you're born before that, there's a presumption of non-availability. Therefore, the non-availability certificate is not needed. Then it's just secondary evidence, birth affidavits from people that were present at the time of your birth. Those birth affidavits have to state how those people know you, their relationship to you, and that they were present at the time of your birth. They are aware of that when you were born, and that has to be notarized. And if they are in India, those people who are giving that affidavit, then it also has to be on stamp paper and notarized. So that's the situation with birth certificates. And sometimes with the birth certificates, there are issues with the birth certificates. For example, it's quite common sometimes that the baby is not born at the time that the birth certificate is. The baby is not named
That's
at the
quite all
time
right.
that birth certificate is issued.
Right.
See, I'm talking so much that I'm losing track of what I'm saying. That's what happens when we have more callers, I get a rest. But
Right.
yeah, so basically that's what it is. So since the baby is not named at the time of the birth, sometimes, especially in India, they wait for the 21st day or whatever, to name the baby, according to our Hindu custom. So there'll be a blank birth certificate, meaning there won't be any name on the birth certificate. The parents' names will be there, and the gender will be there, male, female, but there won't be any name on it. In that situation, that birth certificate is also valid, but that has to be backed up by secondary evidence to show that that birth certificate actually belonged to you, and so you could get affidavits again, school leaving certificate, etc., which has the same date of birth as is on the birth certificate. So sometimes there's misspelling. The names are there, but they're misspelled. Sometimes they have nicknames on the birth certificate, or so anything that is needs explanation on the birth certificate, that can be done via the secondary evidence that I just mentioned. So in all those situations, then secondary evidence would be required just to consolidate, the information on the birth certificate. So in addition to that, we'd also need then, as I said, proof of relationship means marriage certificate. So if you're filing for your wife without a marriage certificate, they will not approve your wife's 485 because that's the only proof of relationship. But again, a marriage certificate, since the event happened more recently than the birth certificate, is more easy to obtain, and most people have marriage certificates. So I've very few instances where in family-based petitions, if you're filing for your parents, maybe they may not have a marriage certificate, but otherwise, most people filing for employment-based cases are in their, maximum in their 50s, or so. So most of them have marriage certificates. So if you don't, again, then you'll have to submit a non-availability, the same thing that you did on the birth certificate with, additional evidence to show that you were born, secondary evidence to show that you were married on so-and-so date and so-and-so is your spouse. So those are, and then the other thing that you would need, there's something called the public charge document, but luckily the public charge law is not in place right now, so we don't have to worry about that as much. But in last October, it was in place, and I hear that it might again become a requirement. They're looking into it. But if that becomes a requirement, then you need all this public charge documentation, which includes the form for the public charge, and also proof that you will not only that you're presently not taking money from the government, that you're not presently, but also that in the future you're unlikely to ever become a public charge. So that's something, if it comes back again, then you might have to submit documentation showing that. Let me see, what else am I missing? In addition to that, of course, you have to submit the medicals, and the medicals have to be within 60 days of you filing the petition, otherwise they become stale. And the medicals have to be sealed and signed by the doctor. So make sure, sometimes you send unsigned medicals and you don't know that they're not signed because they're sealed and given to you by the doctor, and then you'll get an RFE asking for another set of medicals. So that's quite common for that to happen. So make sure that you ask for a copy of your medicals from the doctor's office so that you can make sure that they're signed. And of course, if you have any ailments, like maybe like a diagnosis of TB or any other disease that could disqualify you from possibly getting the 485, then you would need a note from the doctor, or they might ask for additional documents, diagnostic documents to show that the ailment was treated and it's been cured, etc., etc. Sometimes, especially for Indians, in the medicals, it shows that you have or have had tuberculosis at some point. Right. So in that instance, then you need X-ray, and the doctor will do that. You'll need an X-ray to show that your lungs are clear presently and that you don't have any TB. So that's some, documentation that you might need, the medicals. In addition, of course, make sure you write the correct check at 1225. Write it out to the correct name. It's not USCIS, it's not INS, it's not immigration. It's U.S. Department of Homeland Security. So you have to write, make sure you write it to the right person. Date it. If you put a past date or future date, obviously the check will not be honored. Sign it. Make sure the words and the numbers coincide. So, all this is what we look at when we file a petition. Yeah. Because Reddy, if any of this is,
Sorry to cut you in between. We have a caller on hold. Mr. Gopi from Florida is on the call. So thank you for calling, Mr. Gopi. You may ask Ms. Reddy your question directly.
Hi, ma'am. I have a question regarding the I-140 premium processing request. I went for the downgrade in last year, October, and 15 days back, 2 weeks back, my lawyer requested for the premium process for I-140. But as of now, the check is not cashed and the package is not come back. So I don't know what is the status. Is there any possibility to check the status whether they accepted or not? Is there any email address or something we can send an email to service center saying that what is the status of premium process request accepted or not for the I-140?
How long has it been?
It's 2 weeks back. I sent it.
So that's not enough time. You have to give it more time. 2 weeks there's not enough time for them to send it back or for you to know whether it's accepted or sent back.
Yep.
It can take longer. I would give it at least a month.
So
To get a receipt or
acceptance is for month.
to get the receipt. Because how do you know whether it's accepted or not until you actually get the receipt?
Not
Also,
receipt.
you can check.
We already
can,
have a receipt. I am trying to upgrade to the premium process for the
I'm talking about premium
EB3
processing
credit.
receipt. Yes, I'm talking about the premium processing receipt. So you only know that it's accepted once you get the premium processing receipt. Did you get that?
No, not yet. That's what I want to know.
Okay, so that's what I'm talking about. Exactly. That's what I'm talking about when I say receipt. Okay, I'm talking about the premium processing receipt. So you have to wait to get the receipt. Sometimes it can take some time. So it's only 2 weeks. I wouldn't be surprised if it takes a little longer. Or you can also find out if the check has been cashed. Depending on who's given the check, they can find out from their bank if the check has been cashed. If it's been cashed, then usually if you get the check back, cash check, the receipt number will be at the back of the check, so you know that once you have a cash check that it's accepted. Otherwise, sometimes when it's not accepted, they take up to a month to send it back. They don't send it back immediately. They take their own sweet time to send it back. So how would you know? I would say you have to wait, because 2 weeks is not a long time in the scheme of things. But if you want to, you can call USCIS customer service and open a service request, as you might already be familiar with that. It's rather difficult though to ask them to track it, because it's kind of hard for them to track premium processing requests until you have a premium processing receipt. So it's like a chicken and egg situation. But it's possible you might be able to talk to someone. And remember, if it's an I-140, you cannot call, your employer or the attorney has to call. But they might be able to talk to an officer or talk to someone to find out whether that request has been granted or not. But even in that, there's a delay, because they'll say wait for 30 days. Any service request, they'll say wait for 30 days, wait for 60 days. So I think you just have to be patient in this situation. There's no harm in doing a service request. Go ahead and do it.
Right. Well, that was some sound advice. Is there any? Are there any other documents that we need for filing an I485? Is there anything else?
What was I talking about? I completed the medicals. Yeah.
The medicals. Yeah.
Done with the medicals. Done with the check. And then of course you need photographs. 6 photographs if you're doing advanced parole and EAD, and because they need to put the photograph on your green card, and they also put the photograph on your the card, EAD AP card. So they need and they keep the rest of the photographs in the file. So they need 6 photographs, 2 for each application. And remember, the check for a person under 14 is a different amount from the check for an adult. So make sure you know what the filing fee is. And also, most importantly, a 485 form, the other document that you're sending out are all the forms, of course, and they all have to be signed, and they all have to be filled out correctly, and you don't leave any blank spaces. And if the child is below 14, then the mother or father has to sign and say mother or father in brackets, so they know that it's the mother that signed. The child cannot sign. If the child signs, then the 485 application will come back, and then you may not be able to file it because the priority date is no longer available. So make sure the signatures are done properly by the proper people. And if you're over 14, then the child can sign. So these are some things that most people don't know, and sometimes the attorneys in their rush, like the craziness that we had in last October, they may not notice also, or they may not intimate the client as to who has to sign. So, often I see that this, I've been told by people that have come to me and said that, look, the case came back, this is what happened, our attorneys didn't tell us that, the child can't sign, etc., etc. So just be careful with reference to who signs. I think that's about it. We've covered most of the documentation. We can go more in depth when we get a chance, maybe on the next call. But I think this is the basic documentation that you need to submit to the 485.
Right, I agree with you. We've had a very informational show this time. I mean, you've given us a lot of information and such vivid insights about how the immigration visas work. And thank you for that. It was a privilege hosting you. And what is your golden message to our viewers?
Don't try to do it yourself. Always take help. Let the experts file the immigration petitions for you. It's like, me trying to do my taxes myself. I know a lot of people do their taxes themselves, but I prefer to outsource what is not my area of expertise. If I had to write a will, I wouldn't do it myself. Even though I'm an attorney, I would go to someone that has an expertise in that area. So, don't do it yourself. Get the proper experts to help you.
Brilliant. That was brilliant advice. It was pleasure having you on the show, Ms. Reddy. Thank you so much.
Thank you, Dharani. Good night.
Good night. You're watching Sakshi TV Live with me, Torini Makana. Thank you.